All names, places, and institutions are aliases used to protect privacy. Procedures and timelines reflect real-world law and forensics for immersion. The holding cell smells like floor wax and old metal. Detective Harbour sits across the reinforced glass partition, a manila folder thick with depositions, DNA reports, and appellate motions spread across the metal table before him. 23 years on the force. Harbour has testified in courts 1,000 times, but today he is not testifying. Today, he is sitting in silence while the man he arrested in June 1995 reads through documents that will decide within hours whether everything Harbour believed about the case was constructed on a foundation of error and oversight. 47 minutes remain before the evidentiary hearing begins in Granite County Superior Court. Rook, the man across the glass, is 54 years old now. His hair is grey at the temples, his face lined with the particular exhaustion of someone who has spent 19 years in a cell for a crime he did not commit. The Orange County jumpsuit hangs loose on his frame. His hands, weathered and steady, move slowly through the motion papers. The documents tell him what he has suspected since March. The DNA profile recovered from the victim's body does not match his. It never did. The lab in Arcadia confirmed this in November 2022, after new testing was conducted using STR profiling, technology that did not exist during the original investigation in 1995. The male profile found at the crime scene belongs to an unknown perpetrator. Not Rook, not once, not partially, not by any measure, virtual certainty, exclusion across all genetic markers tested, but Rook was convicted anyway. Sentenced to 45 years to life. Released on parole consideration only after serving 25 years, which he did. Now, after 19 years inside, the truth is finally, mathematically, inarguably documented in a lab report. If you are watching this story, if you have wondered how an innocent person can be convicted despite exculpatory evidence, please subscribe and leave a comment with your thoughts. This is a narrative of how the system failed, how evidence was buried, how time became both the problem and the solution. The machinery of justice is precise in theory. In practice, it bends. Today we follow how it bent around Rook and how, decades later, it finally straightened. The crime occurred on Tuesday, June 14, 1995. The victim, Cypher, was a 28-year-old pediatric nurse at Riverbend General Hospital. She lived in a ground-floor apartment in the Meadowbrook complex, a cluster of 12 units arranged around a central courtyard in Riverbend, a mid-sized city in the northeast with a population of roughly 180,000. At 7:34 a.m., Cypher's roommate, Witness Delta, returned from an early shift at the hospital and found the bedroom door ajar. Cypher lay on the floor, face down, her body showing signs of severe trauma. Police arrived within 12 minutes. The crime scene was brutal. Cypher had been asphyxiated. A ligature mark was visible around her neck, consistent with manual strangulation. Her skull showed blunt force trauma from at least 2 impacts. Her clothing was torn. The apartment's front door lock had been forced, the wood around the frame splintered, indicating forced entry. The bedroom was in disarray, the nightstand overturned, drawers pulled open, Cypher's handbag emptied on the living room floor. Her wallet lay open, cash removed. The scene suggested robbery as a motive, though Cypher's family later confirmed that items of obvious sentimental value, photographs, a grandmother's ring that had been on her dresser, remained untouched. The perpetrator appeared to have taken only cash, roughly $200. Riverbend Police Department mobilized quickly. The case was assigned to Detective Harbour, then 40 years old, ambitious, eager to demonstrate competence in a jurisdiction where violent crime had risen 13% year over year. Harbour had a reputation for closing cases fast. He was respected by the district attorney's office and by the local media, which referred to him as the closer. Crime scene investigators documented the scene over 7 hours. Photographs from multiple angles, precise measurements, swabs of blood, and biological material collected from the bedroom, bathroom, and living room. The medical examiner, Dr. Vessel, performed an autopsy and determined that death had occurred between 5 and 7 a.m., a narrow window, typical for such cases. The biological swabs collected from the victim's body were labeled, initialed, placed in sterile tubes with preservative solution, and transported to the Arcadia Lab, the regional forensic facility serving 5 counties. Within 72 hours, Harbour had a suspect. A neighbor, witness Delta, reported to police that on the morning of June 14th, she had observed a man matching the description of someone she had seen in the building before. The man, Delta said, was tall, dark-haired, wearing a denim jacket, and he was walking quickly down the corridor near Cypher's apartment around 6:15 a.m. Delta added that the figure seemed to be moving with purpose, and that she thought it odd. She had not seen his face clearly. She was focused on her own task, retrieving her car keys from her apartment before leaving for work, and had glimpsed the figure only peripherally from perhaps 30 yards away in the dim lighting of the corridor. But when shown photographs of individuals who worked in the building, Delta pointed to one, Rook, a 26-year-old handyman who had performed repair work in the Meadowbrook complex roughly 6 weeks prior. Rook had a record of legitimate work. He had been contracted by the building's maintenance coordinator to repair plumbing and drywall damage in 3 units. Multiple residents had observed him working over the span of a week. He had access to the corridor. He knew the layout of the building. He was known to the property manager, but there was no indication prior to Delta's report that Rook had ever interacted with Cypher or had any motive to harm her. Harbour brought Rook in for questioning on June 16, 1995. Rook arrived voluntarily, cooperating fully. He was not yet a suspect in the formal sense, but Harbour's tone made clear that he was of interest. The interrogation took place in an interview room at the Riverbend Police Department, with Harbour and a junior detective, Officer Thorne, present. No recording device was activated. This was 1995. And Riverbend had no mandatory recording protocol for felony interrogations. No video, no audio. Only Harbour's handwritten notes, taken in real time on a yellow legal pad. The interrogation lasted 2 hours and 40 minutes. According to Harbour's notes, Rook initially denied being near the building on June 14th. He said he had no reason to visit. He did not know Cypher. He had completed his repair work 6 weeks prior and had not returned since. Harbour pressed him. Harbour presented the neighbour's statement. Harbour emphasized that witness Delta had identified him. Harbour suggested that the timeline placed Rook near the crime scene. Harbour noted discrepancies in Rook's account. Rook said he was home alone that morning, but offered no witnesses. Rook said he had no knowledge of Cypher, but Harbour pointed out that Rook's work had taken him through the same corridor where Cypher lived. After 90 minutes of questioning, according to Harbour's notes, Rook's certainty began to erode. He said, "I don't know. Maybe I was there. I don't remember." Harbour's notation: subject exhibits confusion, possible admission. Subject states he may have been in the building, but claims memory loss regarding June 14th morning. Harbour continued. He described the crime to Rook in detail: the body, the trauma, the violence. He asked Rook if he was capable of such brutality. Rook said no. Harbour asked if Rook had ever been attracted to Cypher. Rook said he did not know her. Harbour asked if Rook had stolen money from the apartment. Rook said no, but by this point, according to Harbour's notes, Rook was increasingly agitated and unable to provide a coherent account of his movements. Harbour concluded the interview with a final assertion. "We have a witness who places you at the scene. We have forensic evidence. We have motive. Tell me what happened." Rook's final words, as recorded in Harbour's handwritten notes: "I want a lawyer." Harbour documented this, ended the interview, and arrested Rook on the spot. The charge: murder, aggravated assault and burglary. The biology of the crime scene now became central. At Arcadia Lab, forensic analyst Slate received the swabs taken from Cypher's body. Slate was experienced. 15 years at the lab, over 2,000 cases processed. The swabs included material from the victim's mouth, her hands, and her vaginal cavity. Standard procedure in sexual assault cases. The swabs were logged into the evidence system at 2:17 p.m. on June 15, 1995. Each swab was labeled with a case number, initialed by Slate and placed in a sterile tube containing a preservative solution designed to inhibit bacterial growth and stabilize DNA. But there was a procedural lapse. The tubes were placed on a bench in the evidence room at ambient temperature, approximately 72 degrees Fahrenheit, rather than being immediately transferred to the refrigerated unit reserved for biological samples. This was not deliberate. It was an oversight. The lab was processing 43 cases that week. Slate was supervising, but he did not personally verify every transfer. The swabs remained at room temperature for 48 hours before being moved to cold storage on the morning of June 17th. 48 hours. At room temperature, with bacteria active, with molecular degradation accelerated by temperature and light exposure, Slate conducted preliminary serological testing on June 20th. The blood at the scene matched Cypher's blood type, O positive. The semen recovered from the vaginal swab was blood type O, consistent with approximately 40% of the male population, including Rook, who was type O. The results were typed as inconclusive but consistent with defendant. Slate prepared a memo dated June 20th, 1995. In that memo, he noted, "Vaginal swab stored at ambient temperature for 48 hours prior to refrigeration. Sample shows degradation consistent with exposure. If DNA profiling were to be conducted, sample integrity should be noted as potentially compromised. Recommend RFLP testing be deferred pending further analysis." This memo was filed in the case jacket at Arcadia Lab. It was not, however, transmitted to the Riverbend Police Department. It was not sent to the District Attorney's Office. It was not disclosed to the defense. It was evidence of a potential Brady violation, material information regarding the reliability of biological evidence that should have been disclosed but was not. Rook was charged formally on June 24, 1995. He was arraigned before Judge Keystone on June 26th. Judge Keystone was 58 years old, a former prosecutor known for expedited dockets and skepticism toward defense motions. Rook was assigned a public defender, Attorney Archer, from the Riverbend Public Defender's Office. Archer was competent but overwhelmed. His caseload at that time was 187 cases. Rook was one of many. Archer requested a preliminary hearing to challenge the sufficiency of evidence. The hearing was held on July 10, 1995. Harbour testified to Rook's interrogation, reading from his notes. Archer cross-examined Harbour briefly, but did not press hard on the lack of recording or the ambiguous nature of Rook's statement. Witness Delta testified that she had seen a man matching the description of someone she had encountered in the building. Archer asked Delta if she had seen the man's face. Delta said no. Archer asked if she was certain of the time. Delta hesitated and said, approximately 6:15. Archer asked if she was absolutely certain. Delta said she was fairly sure. Slate testified that semen recovered from the victim matched Rook's blood type and that no exclusionary markers were found. Archer did not request a copy of Slate's memo. He did not know it existed, Judge Keystone found probable cause and bound Rook over for trial. The preliminary hearing lasted 2 hours. Trial was scheduled for October 1995. Archer filed motions to suppress the interrogation, arguing that the lack of recording violated Rook's rights, but Judge Keystone ruled that recording was not mandated under state law in 1995, and that Harbor's notes were sufficient documentation. Archer filed a motion to discover all forensic reports. The district attorney's office provided Slate's serological results, but did not include the memo regarding storage conditions and degradation. Archer did not know to ask for it. It was filed at Arcadia Lab, not in the district attorney's office, not in any document management system that Archer could access through discovery protocols. The trial began on October 2, 1995, before Judge Keystone and a jury of 12. Prosecutor Sinclair, 34 years old, ambitious, eager to convict, presented the state's case over 3 days. The narrative was straightforward. Rook had been to the building before. Rook knew the layout. Rook was seen near the scene on the morning of the crime. Rook possessed motive. He had recent financial pressures and was known to seek cash jobs. Rook could not account for his whereabouts. And most damaging, according to Prosecutor Sinclair's theory, Rook's initial denials had crumbled during interrogation, and he had admitted to possibly being at the crime scene. Prosecutor Sinclair called witness Delta. Delta testified that she had seen a man matching Rook's description near the building at approximately 6:15 a.m. on June 14th. Archer cross-examined Delta and established that she had not seen the man's face, had glimpsed him peripherally from a distance of 30 yards in dim lighting. Archer asked Delta if she was certain it was Rook. Delta said she was fairly sure, maybe 80% sure. Archer pressed further. Delta acknowledged that she had not recognized Rook at first. She had only identified him when shown photographs by Harbor. Archer asked Delta if she often saw strangers in the building. Delta said yes. The building was on a transit corridor, and people moved through it regularly. But under Archer's questioning, Delta's certainty softened. Her memory was not a photograph. It was an impression. Prosecutor Sinclair then called Detective Harbor. Harbor testified to his investigation, his interview with Rook, and Rook's statement that maybe I was there. Harbor testified that Rook's hesitation, his inability to provide a clear alibi, and his eventual words suggested consciousness of guilt. Archer asked Harbor if the interrogation had been recorded. Harbor said no, it had not been recorded. Recording was not required in 1995. Archer asked Harbor to read his exact notes of Rook's statement. Harbor read, "I don't know. Maybe I was there. I don't remember." Archer pressed Harbor on the context. Archer asked if Harbor had spent 2 hours suggesting to Rook that he was at the scene, if Harbor had described the crime in detail, if Harbor had implied that evidence pointed to Rook's guilt. Harbor said he was conducting a proper investigation. Archer asked if the lack of recording made it impossible for a jury to assess Harbor's tone, the length of questioning, or the pressure applied. Judge Keystone sustained an objection from Prosecutor Sinclair, ruling that Archer's questions were argumentative. Prosecutor Sinclair called Dr. Vessel, the medical examiner. Dr. Vessel testified that Cypher had died from asphyxiation and blunt force trauma, that the attack was brutal and violent, and that evidence suggested a sexual component to the assault. The jury absorbed this testimony with visible emotional reaction. The image of Cypher, murdered in her own apartment, was a powerful one. Prosecutor Sinclair then called forensic analyst Slate. Slate testified that semen recovered from the victim's vaginal area matched Rook's blood type, type O, and that no exclusionary markers were found. Slate testified that the biological material was consistent with the defendant. Archer asked Slate if the results definitively proved Rook was the source. Slate said blood typing could not definitively prove identity, but was consistent. Archer asked Slate if blood type O appeared in 40% of males. Slate said yes, approximately. Archer asked Slate if he had any information about the storage or handling of the samples that might affect reliability. Slate said no. It was technically true. Slate had filed the memo at Arcadia Lab. Slate had not disclosed it to the prosecution, and so could answer truthfully that he had not conveyed such information in documents provided to the district attorney. Archer had no forensic expert to challenge Slate's testimony. His budget would not allow for an independent consultant. Archer's cross-examination was skillful but limited. Prosecutor Sinclair then called Rook himself as a witness. This was a risk, and Archer was uncertain, but Rook insisted. Rook testified that he had worked at Meadowbrook 6 weeks prior and had not returned since. He testified that he did not know Cypher. He testified that on the morning of June 14th, he was alone in his apartment and could not prove otherwise. He testified that he did not assault anyone, did not steal anything, and did not kill anyone. Under cross-examination by Prosecutor Sinclair, Rook's answers became emotional. Sinclair pressed Rook on his statement to Harbour, "Maybe I was there." Rook explained that he had been confused, that Harbour had been asking questions for hours, that he had been frightened and disoriented. Sinclair suggested that this confusion was, in fact, consciousness of guilt. The jury watched Rook's distress. It was ambiguous whether they interpreted it as fear or culpability. Archer's closing argument emphasized reasonable doubt. Archer noted the vague eyewitness identification, the unrecorded interrogation with an ambiguous statement, and the blood-typing evidence that applied to millions of men. Archer argued that circumstantial evidence, standing alone, was insufficient. Archer asked the jury, "If you are not certain, if you have reasonable doubt, you must acquit." The jury listened. But the image of Cypher, dead, assaulted, murdered, was powerful. The jury had heard of a sexual assault. They had heard of robbery. They had heard a confession, however ambiguous, and an inability to provide an alibi. Prosecutor Sinclair's closing argument was brief and forceful. She reminded the jury of the victim's injuries, of the forced entry, of the sexual assault, of the robbery. She reminded the jury of witness Delta's identification and of Rook's statement to Harbour. She reminded the jury that Rook could not account for his whereabouts. She told the jury that they need not have a video recording to convict. Circumstantial evidence was sufficient if it pointed to a single, reasonable inference of guilt. The jury deliberated for 3 hours and 40 minutes. They voted guilty on all counts: murder, aggravated assault, and burglary. Sentencing was set for November 1995. Judge Keystone imposed a sentence of 45 years to life, with parole eligibility after 25 years. Rook was 26 years old. He would be 51 before he could request parole. The years in prison were long. Rook was transferred to the State Correctional Facility at Coldwater, a medium-security prison in the northern part of the state. He was classified as a violent offender, given his conviction for murder. He was placed in a cell with 2 other inmates in a dormitory housing unit. He worked in the kitchen for $5 per week. He enrolled in the prison education program and obtained his general equivalency diploma. He attended cognitive behavioral therapy, though the program made clear that it was designed for inmates who acknowledged their crimes. Rook did not acknowledge a crime he had not committed. The therapist noted his lack of insight and suggested that he was in denial. His sister Calla visited monthly for the first 5 years. She held his hand across the visiting room table and asked about his health, his state of mind, his hope. Over time, Calla's visits became less frequent. She had her own life, a job, a home to maintain, relationships that demanded attention. She visited quarterly, then annually. She sent letters. She advocated. She wrote to his attorneys, to the public defender's office, to the district attorney, to the governor. In 2005, Calla wrote to the Innocence Project, a national organization devoted to exonerating the wrongly convicted. The Innocence Project reviewed Rook's file and found it compelling. The weak eyewitness identification, the unrecorded interrogation, the inconclusive forensic evidence, but determined that DNA testing at that time would not be determinative. DNA testing at the original crime scene would not exclude Rook unless the perpetrator's profile was found and Rook's profile was absent. The technology existed to do this, but the legal framework did not. State law did not provide a mechanism for post-conviction DNA testing as a matter of right. Rook appealed his conviction directly. The appellate court, in a decision dated March 1997, affirmed his conviction. The court found no error in Judge Keystone's ruling that interrogation recording was not required. The court found the circumstantial evidence sufficient to support a guilty verdict. The court noted that a conviction need not rest upon direct evidence of guilt. Circumstantial evidence, if it points to a single reasonable inference of guilt, is legally sufficient. The court did not address the forensic evidence in detail, as the evidence was merely corroborative of the other facts presented. No mention was made of the memo regarding sample degradation. That memo remained filed at Arcadia Lab, unseen by appellate courts, unknown to Rook's legal team. Rook filed a motion for post-conviction relief in 1998, arguing that his trial attorney, Archer, had provided ineffective assistance of counsel by failing to request DNA testing. At that time, state law did not authorize post-conviction DNA testing as a right. The motion was denied. Rook remained in prison. In 2010, Rook was eligible for parole consideration. He appeared before the parole board. He maintained his innocence. He had no write-ups, no infractions, no evidence of violence during his 15 years inside. The parole board noted his good institutional behavior, but emphasized the severity of his crime and the lack of remorse. The board also received a letter from Cypher's mother, victim's mother Iris, who opposed parole. "My daughter was murdered," Iris wrote. "Her murderer should not walk free while I grieve her." The parole board denied parole. Rook remained in Coldwater. In 2013, Rook appeared before the parole board again. The result was the same: parole denied, remorse noted as absent, institutional behavior noted as good but insufficient to overcome the original crime. But in 2014, the state legislature passed the Actual Innocence Act. Under its provisions, an inmate could petition for DNA testing of preserved biological evidence if he could demonstrate by clear and convincing evidence that 1. The evidence was preserved and remains intact. 2. The evidence was material to a critical issue in the case. 3. The proposed testing could produce results that would likely change the verdict or sentence. And 4. The inmate had not previously had the opportunity to request such testing. The statute was retroactive. It applied to cases decided before its passage. Suddenly, Rook had a pathway. In early 2022, Rook wrote to the Innocence Clinic at Northeast University. The clinic was run by Attorney North, a former state prosecutor who had left the district attorney's office to defend the wrongly convicted. North had a small staff, 2 assistant attorneys, 1 investigator, and law student interns. She received over 500 inquiries per year and could accept fewer than 20 cases. She reviewed Rook's file, trial transcript, appellate decision, crime scene photographs, original lab reports from Arcadia Lab dated June 1995. And on a second reading of the 1995 lab reports, North saw it. A memo dated June 20th, 1995, filed in the case jacket at Arcadia Lab. The memo stated, vaginal swab stored at ambient temperature for 48 hours prior to refrigeration. Sample shows degradation consistent with exposure. If DNA profiling were to be conducted, sample integrity should be noted as potentially compromised. This memo had never been disclosed to the defense. This was Brady material, evidence that went to the reliability of a critical piece of evidence, the biological material recovered from the victim's body. Under Brady v. Maryland, the prosecution has an affirmative duty to disclose materially exculpatory evidence to the defense. Degradation of a biological sample is materially exculpatory if it speaks to whether that sample could reliably identify the true perpetrator. The failure to disclose it was a Brady violation. North filed a petition for DNA testing under the Actual Innocence Act in May 2022. The petition included an affidavit from Dr. Marker, a forensic biologist with 20 years of experience. Marker testified that the storage conditions described in the 1995 memo, ambient temperature for 48 hours, created a serious risk of sample degradation and contamination. Marker stated that in 1995, DNA profiling technology was primitive compared to modern methods, but that the fact of potential degradation should have been disclosed to the defense so that the defense could challenge any inferences drawn from the biological evidence. Marker concluded that retesting using modern STR profiling technology, which requires less DNA and is more discriminating than the technologies available in 1995, could definitively establish whether Rook's profile matched the recovered samples. North attached copies of the 1995 memo, the trial transcript, the appellate decision, and a detailed legal analysis of the Brady violation. Prosecutor Sinclair received the petition. She was no longer the aggressive young prosecutor who had convicted Rook in 1995. She was, in 2022, the Chief Deputy District Attorney with 27 years of experience. She reviewed the file. She saw the memo. She consulted with her supervisor, District Attorney Judicial. They discussed their options. They could oppose the DNA testing petition. They could argue that Rook had been convicted in 1995 and that the passage of time and the passage of DNA technology did not retroactively undermine the conviction. They could fight. But Prosecutor Sinclair decided not to. In a response filed in June 2022, she wrote, "The state does not oppose the petition for DNA testing. The integrity of the biological evidence in question has been disputed since 1995. Modern DNA profiling technology is more sensitive and more discriminating than the technology available in 1995. The state believes that clarifying the identity of the biological material recovered at the crime scene serves justice and the interests of the victim's family." It was a small statement, a few sentences, but it opened a door. In June 2022, the preserved vaginal swab was retrieved from the Arcadia Labs evidence vault. It had been stored in a freezer since the original case was concluded, sealed in its original tube with its original label, initialed by forensic analyst Slate on June 15, 1995. The chain of custody document was intact, received at Lab 2:17 p.m., June 15, 1995, stored cold, June 17, 1995, archived 2000, transferred to Secure Vault 2010, retrieved for testing June 22, 2022. Every transfer documented, every signature initials verified. North coordinated with a private DNA laboratory, Gen Profile Inc., that specialized in complex cases and post-conviction testing. The lab received the swab on July 1, 2022. The sample was thawed, a portion was extracted using sterile protocols, and DNA amplification was conducted using current STR methodology. Short tandem repeats, the gold standard of DNA profiling. The assay examined 13 genetic loci, plus amylogenin for sex determination. The results were conclusive. The male DNA recovered from the vaginal swab did not match Rook's profile. Not at one locus, not at any locus. The comparison was performed twice to eliminate any possibility of technical error. The result was virtual certainty, a match probability of less than 1 in 1 billion, but there was more. The profile was entered into the state's DNA database, which contained profiles of all convicted offenders and arrestees statewide, over 900,000 profiles by 2022. The unknown male profile from the crime scene did not match any profile in the database. The perpetrator remained unknown, but the perpetrator was not Rook. The perpetrator was someone else entirely. The lab report was issued on November 2, 2022. North received it and read it twice, confirming every detail. She called Rook at Coldwater. "The DNA," she said, "does not match you. You are exonerated. We are filing a motion for immediate release." North filed the motion on November 15, 2022. The motion requested that the conviction be vacated, the charges dismissed, and Rook released immediately. The motion was supported by the DNA report, the affidavit from Dr. Marker, the 1995 degradation memo, a detailed legal analysis of Brady, and a request for an evidentiary hearing. The evidentiary hearing was scheduled for March 15, 2023. Judge Meridian, a judge appointed to the bench in 2010, presided. Judge Keystone had retired and was now deceased. The courtroom was filled. Rook was present in his Orange County jumpsuit, shackled at wrist and ankle. Attorney North sat beside him. Caller sat in the front row behind the defense table, hands clasped in front of her. Prosecutor Sinclair was present with an assistant. Dr. Marker was present to testify. A court reporter documented every word. The proceeding was filmed and recorded. Attorney North called Dr. Marker as her first witness. Marker testified to his background, 25 years as a forensic biologist, over 5,000 cases consulted on, publications in peer-reviewed journals. Marker testified that he had reviewed the 1995 memo regarding storage conditions and the 2022 DNA report. Marker explained that in 1995, the lab had primitive DNA profiling capacity. RFLP testing, the standard of the time, required a large DNA sample and was destructive. The sample would be consumed in the testing. The decision not to conduct RFLP testing in 1995 was reasonable, given the technology and the destructive nature of the test. But the fact of sample degradation due to improper storage was not reasonable to withhold from the defense. An attorney, Marker testified, cannot effectively challenge forensic evidence if he does not know that the evidence may be compromised. If the defense in 1995 had known about the storage conditions and the degradation notation, the defense could have hired an expert to explain to the jury that the biological evidence was unreliable, that the inference of Rook's guilt based on blood typing was speculative. The jury was deprived of that information. This was a Brady violation. Prosecutor Sinclair did not cross-examine Marker aggressively. She asked a few questions, confirming that Marker had not conducted the original testing and therefore could not speak to what forensic analyst Slate intended, but did not challenge Marker's core testimony. Attorney North then called Rook himself. He testified, his voice steady. "I did not kill Cypher. I did not steal from her apartment. I did not assault her. I was alone on June 14, 1995, and I could not prove it then, but the DNA proves it now. I have been in prison for 19 years for something I did not do. I want to be clear. I do not know who killed her. I hope you find them. I hope her family gets justice. But I have paid for a crime that I did not commit, and I'm asking this court to set me free." The courtroom was silent. Attorney North presented exhibits, the 1995 degradation memo, the 2022 DNA report, the chain of custody documents, the lab comparison showing no match at any genetic locus. North presented the trial transcript and highlighted the weakness of the eyewitness identification. Witness Delta had not seen a face, had only a vague impression, and was 80% sure at best. North presented Harbour's interrogation notes and highlighted the ambiguity of Rook's statement, "Maybe I was there," and the unrecorded nature of the interrogation, which made it impossible to assess the context, tone, and pressure. North presented the serological evidence from 1995, which was merely consistent with Rook's blood type, but could have applied to millions of men. North's closing argument was measured and precise. "Your Honor, the evidence upon which the conviction of my client rested in 1995 has been thoroughly impeached by technology that did not exist then and by information that was withheld from the defense. The Brady material, the memo regarding sample degradation, speaks to the reliability of the biological evidence that the prosecution relied upon. The new DNA evidence conducted with modern technology definitively excludes Rook from the biological material recovered at the crime scene. There is no forensic evidence linking my client to this crime. The eyewitness identification was weak and unreliable. The statement to police was equivocal and obtained in an unrecorded interrogation of unknown duration and pressure. Your Honor, my client is actually innocent of this crime. The conviction must be vacated. The charges must be dismissed. My client must be released." Prosecutor Sinclair stood. She did not argue for conviction. She said, "The state concurs. The undisclosed memo regarding sample degradation is Brady material. The new DNA evidence is exculpatory and conclusive. The conviction cannot stand. We join in the motion to vacate, dismiss, and release." Judge Meridian deliberated for 30 minutes. She issued a written order. The conviction of Rook for murder, aggravated assault, and burglary is vacated. The charges are dismissed. The defendant is ordered released from custody immediately. The court finds that the undisclosed forensic memo constitutes Brady material that was material and exculpatory, and that the new DNA evidence establishes actual innocence by clear and convincing evidence. So ordered, this 15th day of March, 2023. Rook was processed out of Coldwater Prison on March 22, 2023 in the morning. He was 54 years old. He had spent 9,339 days inside. He was released with a discharge folder containing his release papers, a state ID, a bus pass, and $75 in gate money, the standard discharge allowance for all released inmates, insufficient to begin a new life, but representing the state's formal gesture of transition. The first phone call Rook made was to Caller. They met at a diner near the prison, and they held each other for a long time. Caller wept. Rook stood still, his body registering the reality of freedom for the first time in nearly 2 decades. The machinery of reintegration began slowly. Rook was eligible for a formal exoneration certificate from the state, which arrived in June 2023. He was entitled to file a civil suit for wrongful imprisonment under state law, seeking damages for lost time, lost wages, emotional distress, and damage to reputation. Attorney North connected him with a civil rights attorney, whom he retained. The civil suit was filed against Riverbend Police Department Detective Harbour, Prosecutor Sinclair, Granite County, and the state of Riverbend. The allegations included Brady violation, negligent investigation, constitutional deprivation, and violation of civil rights under state statute. The case was litigated for 18 months. The defendants settled confidentially for $1,200,000. The settlement was not an admission of liability, but it acknowledged Rook's substantial harms. With the settlement funds, Rook rented a small house in a town 2 hours away from Riverbend. He wanted distance from the place of his conviction, from the memories of the courtroom, from the media that had covered his story. He worked part-time as a handyman, the trade he had left behind when arrested in 1995. He was skilled, reliable, and word spread through the small community. He had regular clients who called him for repairs. He struggled, as many exonerees do, with the psychological aftermath of wrongful conviction. He had insomnia. He was startled by sudden sounds, by crowds, by the feeling of being enclosed. He attended a support group for exonerees once a week, held at a community center, where he met others who had been released after post-conviction DNA testing exonerated them. They shared a particular kind of trauma, the trauma of having your entire life taken, justified by the system's certainty, only to discover decades later that the system was wrong. But Rook also began to live. He took a vacation with Caller to the ocean, their first trip together in nearly 2 decades. He adopted a dog, a shelter dog with nervous energy that matched his own, and they bonded through routine and presence. He began to sleep more soundly. He made friends in his small town who knew him only as the quiet, skilled handyman who fixed their leaky faucets and repaired their drywall, not as a man who had been convicted of murder. In late 2023, Rook became active in wrongful conviction advocacy. He gave talks at Northeast University's law school about the intersection of eyewitness misidentification, coercive interrogation, and forensic evidence gaps. He spoke to police officers about the risk of confirmation bias. He testified before the state legislature about post-conviction DNA testing reform. He spoke quietly, without bitterness, but with clarity about how the system had failed him and how it was failing others. In 2024, the original case was reopened as a cold case. The unknown male DNA profile from the crime scene, the profile that had exonerated Rook, was uploaded to CODIS, the national DNA database. No match was found. The perpetrator remains unknown, though the case remains active. Detectives are pursuing leads based on the profile, attempting to identify potential suspects through genealogical DNA databases and historical records. Cypher's family was briefed on Rook's exoneration and on the reopening of the cold case. Cypher's mother, victim's mother Iris, gave a statement to a local reporter. "I grieve the loss of my daughter," Iris said. "I also grieve the loss of this man's life, stolen by mistakes that were made in the investigation and prosecution of her case. I hope they find who did this. I hope my daughter gets justice. But I see now that putting an innocent man in prison was not justice. It was an injustice to him and to my daughter's memory, because it delayed finding the real perpetrator for nearly 30 years. Detective Harbour retired in 2008 and died of a heart attack in 2021, before Rook's exoneration. He never faced public reckoning for his investigative decisions. Prosecutor Sinclair in 2023 gave a statement through her office. "I relied on the evidence presented to me at the time. I did not intentionally withhold evidence, but I should have reviewed all forensic materials more carefully before trial. I should have disclosed the memo about storage conditions and sample degradation. These errors cost an innocent man 19 years of his life. The system failed. I failed. There is no excuse. I'm committed to ensuring that such failures do not happen again, and I have implemented new procedures in my office to ensure that all forensic materials, including internal lab memos, are reviewed and disclosed to the defense as required by Brady." What does this case illuminate? Eyewitness identification, even when offered under oath in court, is fragile. Witness Delta did not see a face. She saw a figure in dim light from a distance of 30 yards while focused on her own task. Yet her identification, once expressed to police and reinforced through the investigation, became a pillar of the case. Decades of psychological research now confirms that eyewitness memory is malleable, subject to suggestion, to reinforcement, and no more reliable than a photograph taken in dim light. The research shows that confidence is no indicator of accuracy. Delta was 80% sure, but she could easily have been mistaken. Interrogation recording, standard practice now in many jurisdictions, would have prevented ambiguity about Rook's statement. The statement, "Maybe I was there," emerged only after 2 hours and 40 minutes of questioning by a detective convinced of Rook's guilt. A video would have shown the interrogation's length, tone, the questions posed, the pressure applied. The jury in 1995 was left with Harbour's handwritten interpretation of events, filtered through Harbour's belief in Rook's guilt. Forensic evidence, when handled improperly, can be unreliable. The memo noting sample degradation was not a secret withheld out of malice. It was filed at Arcadia Lab and simply was not transmitted through the system to the prosecution and then to the defense. But Brady requires disclosure of all materially exculpatory evidence, including evidence regarding the reliability of other evidence. The defense, in 1995, could not effectively challenge the forensic testimony without knowing that the sample might have been compromised. Brady violations, when taken together with weak circumstantial evidence and unreliable eyewitness identification, can send an innocent person to prison for decades. It was not one error. It was the accumulation of several. The vague identification, the unrecorded interrogation, the equivocal statement, the withheld forensic memo, the weak legal defense hampered by resource constraints. Each error, standing alone, might have been survivable. Together, they built a case that looked convincing to a jury, but was, in fact, constructed on a foundation of unreliability. Post-conviction DNA testing statutes, passed in many states over the past 20 years, have exonerated over 350 people in the United States as of 2024. Each exoneration represents a failure of the original conviction process. Each exoneration is a chance to study where the system broke down and how to prevent future failures. In Rook's case, the system broke down in multiple places: the investigation, the interrogation, the forensic evidence handling, the disclosure practices, the trial representation. The system was repaired, eventually, belatedly after 19 years, through DNA technology and through the will of individuals like Attorney North to look at old files and ask hard questions about whether the conviction was really solid or whether it was built on sand. On a quiet street in a town that few have heard of, in a small house with a dog sleeping on the porch, Rook sits at his kitchen table in the early morning. Caller is asleep upstairs, visiting for the weekend. His dog is asleep on the rug, one ear twitching in dreams. The evidence box, the trial transcript, the appellate decision, the police reports, the lab records, the motion and order exonerating him sits on a shelf in the study. He does not open it often. It is a monument to error, a record of time lost, a map of how justice was miscarried and finally, imperfectly, restored. The sun rises over the small town. Rook drinks his coffee. He thinks of Cypher, whom he never knew, but whose death changed his life. He thinks of Detective Harbour, now deceased, a man convinced of his guilt despite insufficient evidence. He thinks of Prosecutor Sinclair, who eventually chose to listen to evidence. He thinks of Attorney North, who saw something in an old file that others had missed. He thinks of the unknown man whose DNA is still in the database, still a cold lead, still possibly findable. Outside the window, a neighbor walks by with her dog. She waves. Rook waves back. He is a person again, no longer a number. He is Rook, the handyman who fixes things, who lives simply, who does not seek revenge or attention. He seeks only to live the remaining years of his life in peace, and to help ensure that the next person arrested for a crime they did not commit might have a faster path to truth than the 19 years he was forced to walk. If you have watched this story, if you have felt the weight of wrongful conviction, please subscribe and leave a comment. The system is not evil. It is made of humans. Humans make mistakes. The question is, when we discover those mistakes, do we correct them? Do we let the innocent person go free? This is the only question that matters.